is in session. The court is in session and calls number 23-CCCR 1897. Case is styled in the state of Texas versus Amber Croft or Amber Danae Croft. Ms. Croft, is that your full name? Ms. Croft, would you please raise your right hand? You swear firm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Ms. Croft, you may put your hand down. How are you doing, Ms. Croft?
I'm good.
I'm doing fine, thanks for asking. Ms. Croft, you're represented in your case by your attorney, Dustin Galmore. Attorney Galmore, how are you doing?
Morning, Judge. Doing good. How you doing?
I'm doing fine, thanks for asking. State is represented in this case by Attorney Haley Simpson. Simmons, how are you doing?
Great, Judge, thank you.
Okay, we have Ms. Denise Hunter
Yes.
from the probation department. Ms. Hunter, how are you doing?
Good. Thanks, man.
You're welcome. Now, Mr. Galmore, I have before me a motion seeking relief from ankle monitor due to indigence. Is that correct?
That's correct, Judge.
And Mr. Galmore, would you like to go forward on your motion?
Well, Judge, I just have arguments. There is an affidavit of indigency that's been attached to the motion. But I just want to make sure that that is still accurate. I believe on the affidavit of indigency, it states that she makes $2,000 per month. Yeah, so it's stated, this affidavit of indigency states that you make $2,000 per month, but I know that there's been maybe some changes because your doctor that you work for was going to have a surgery and you were going to lose some hours. Would you say that 2,000 per month is still the accurate number, or is it less now?
Yeah, it's not bad.
2,000, okay. Just want to make sure that was correct, Judge. According to the affidavit of indigency, her expenditures are higher than her income. I do believe that that makes her indigent as far as purposes of being able to afford anything that's outside of that affidavit. I do know that in the past, she's borrowed money to pay for the ankle monitor, which is why we addressed the court a couple of weeks ago. She wanted the court to be aware that she would not be able to make any further payments before she failed to make the payment. She was trying to be ahead of that, Judge. I know in the past, well, first, the reason why she has it is because probation requested her to participate in some other measures, not an ankle monitor, but because of her work schedule, she was unable to accommodate that. So by agreement, it was decided she would wear the ankle monitor, and she did. And she's had no issues with it. She's been in 100% compliance with it, which is why I believe the probation department in July asked the court to remove it. That request was denied. And then based on her inability to pay, the probation department, I believe a few weeks later, asked the court to consider a cheaper device, the portable, because it's also 24-hour monitoring, which is the same as the ankle monitor, 24-hour monitoring. But that request was denied. That was prior to me being involved, so I don't know
Let's see.
what the court's logic was. She got me involved.
Ankle monitor.
She got me involved, Judge, and just full disclosure, due to her financial abilities, I did not charge her any money to prepare this motion or present it to the court. I'm just trying to help her avoid a motion to revoke her probation. She just simply can't afford $400 a month device, and she doesn't want to be in violation either.
Okay.
I do know that there's a provision that allows the court to pay for some devices. I think that the statute really talks about interlock device. But the issue is just her ability to continue paying the company. They're going to cut it off. She doesn't continue to make payments, and she can't borrow money anymore. She's unable to pay the person back.
Okay, state,
The state just has a few questions for the probation officer.
okay,
If you don't mind. Could you go ahead and state your name for the record?
Denise Hunter,
And when is it that you took on Amber Croft within your caseload?
April 21st, 2025.
And you're aware that she's been placed on probation since March 18th, 2024 for the offense of driving while intoxicated?
Yes, she was previously on another caseload. She successfully completed it and then she was placed with a regular felony officer on my caseload.
Okay, throughout your time with probation and overseeing Ms. Croft, how many times has she committed a violation?
One time.
Okay, and since then, I'm assuming that was with the interlock device?
Well, she tested positive at the probation office.
From there, was it your recommendation that she receive this brand device?
Yes,
Was she agreeable?
yes,
Did she have that installed?
she did.
Has there been 100% compliance since that date?
There has been.
Did Ms. Croft come to you and express that there were financial difficulties?
She did.
And the probation department's recommendation, did they agree to removal of the ankle monitor?
Probation program. Well, we
You
requested.
requested?
Yes,
Okay, and with that, was there an alternative that you had requested?
yes, we requested to place her on a portable alcohol monitoring device in lieu of the scram because it's significantly cheaper.
And Ms. Croft was agreeable to that as well?
Yes,
Okay, there has been no other violations outside of that one incident on May 7th, 2025?
that's correct.
No further questions, Your Honor.
Well, let me ask a question now. In regards to the portable device, now at that time, I think it was stated that she was agreeable to the portable device. Is she still agreeable to the portable device now, or is it because of her financial situation, she cannot even have a portable device?
I have an interlock in my car. I pay over $100 a month for already.
Well, I
And I
understand
really
that.
can't afford it.
I think, Judge, she can't afford the current interlock device, and so what, if the court were to order a portable interlock, which tests her several times per day, I think that an interlock in her car would be redundant, and so if the court did order a portable, I believe the court could order the removal of the interlock, and that way it would reduce her current obligation down by the entire $400 per month. So it would basically be back to what she was originally paying, that she could originally afford.
Sorry, Judge. Well, we discussed her continuing to be monitored by the ignition interlock device and in lieu of the scram being placed on the portable. So that's what we agreed on. And that's what I requested, that she continue with the ignition interlock device because she tested positive and she didn't go into the machine, so it didn't pick it up on the machine. So I would like the portable device to be added also, and Ms. Croft and I discussed it, and she stated that she could afford that, but not the scram device, since her hours have been reduced.
Okay. So let me see, see if I'm getting this straight.
Right.
So you're saying that she'll have the interlock on the car and a portable?
Yes, sir.
That's what you're saying? That's
Yes,
what you
that's what I
requested?
requested. Yes, sir.
Okay, state?
If I may, Your Honor, I have no objections to this request, given the fact that this defendant was placed on the maximum 2-year probation on this offense. Within that time period, it's been about 1.5 years, and she's had 1 violation. Since then, she has been compliant with all terms of probation. She reports as needed. She reports as asked. She has had no other issues, correct?
Correct.
And given that, since there's the financial difficulty, the state would agree to the recommendation of probation.
Okay. So the court is going to grant the recommendation of the probation department that she continue to maintain her interlock, but she'll be required to have a portable alcohol monitoring unit. Okay,
Okay, thank you, Judge.
all right. So that's the order of the court.
Thank you, Judge.
All right. Okay. Okay, you are. Okay, we have Mr. Who we have?
Your Honor, the court should have a dismissal on Mr. Soap and it's.
Mr. Salt, well, we could do the dismissal first. That shouldn't take that long. Justin Distillion Tide Soap.
He's outside.
Somebody can go get him. Thank you, Ms. O. Yes. Court is back in session and cause number 23 CCCR 2660, case of style of state of Texas versus Justilian Todd Soap. And Mr. Soap, you was previously sworn in, is that correct? Okay, now, Mr. Soap, I have before me a motion to forfeit the weapons, in this case to the Rose City Marshal. You recognize this motion? Is this your signature on the line as titled defendant?
Sir,
And before you signed this document, did your attorney go over this document with you?
he did, I just misunderstood it. I thought I was getting them back, forfeit. I didn't know forfeit was giving them up.
Okay, and so now,
I'm still okay with it, whatever it needs to do to get.
so you would like to forfeit these weapons to the Rose City Marshal?
Yes, sir.
Okay? Okay, so the court is going to grant the motions to forfeit the weapon to the Rose City Marshal. And State, you have another motion?
Yes, Your Honor, motion dismissed based on that motion.
Okay, now, Mr. Soap, your case is going to be dismissed, and I'm signing the dismissals. Okay. Mr. Soap, you'll be able to get a copy of the motion to dismiss. Once you get a copy of the motion to dismiss, you're free to go, and you have a blessed day.
Thank you, Your Honor.
Too, thank you.
You're welcome. That's it. Seven. Who is Sierra Crane? Have a dismissal. Oh, that's the motion to revoke probation?
Yes, Your Honor.
Sierra Crane,
And that was based on,
cases. Hmm?
the dismissal is based on, the fact that we found 2 cents to 15 months state jail in the
Okay.
Harris County case.
Okay. I'm signing the dismissal on Crane. That's not so.
Oh, wait.
That's Sadler. She asked for soap. He must have stepped out.
He did. Okay, I guess you want to. I guess tell you gonna get it. Judge, I have,
If drug court did not put a date in the computer, then you'll be free to leave. And our court reporter will continue to check the computer, and then when we get a date, we'll send notice to your attorney and your bondsman. Okay? So just hold on a few minutes. Okay, it's being reset to September 24th. That's the date that they've already reset it. You can come and have a seat in that first chair on the wall, get your reset. Once you get your reset, you're free to go and you have a blessed day. Jefferson County Court at Law number 2 is back in session. The court is in session in cause number 24 CCCR 3192. Case is style okay, it's cause number 24 CCCR 2192. The case is styled the state of Texas versus Dennis Sadler Jr. Mr. Sadler, is that your full name?
Yes, sir.
Mr. Sadler, would you please raise your right hand? Mr. Sadler, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Mr. Sadler, you may put your hand down. How are you doing, Mr. Sadler?
I'm doing good, sir. How are you?
I'm doing fine, thanks for asking.
Good.
Mr. Sadler, you're represented in your case by your attorney, Attorney Christy Cawthon. Attorney Cawthon, how are you doing?
I'm doing well, Your Honor.
That's good. Ms. Cawthon, do you waive a record in Mr. Sadler's case?
I do.
And Mr. Sadler, the state is represented in this case by Attorney Shane Hilton. Attorney Hilton, how are you doing?
I'm good, Your Honor. Thank you.
You're welcome. Now, Mr. Sadler, I have before me on my computer a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Dennis Sadler Jr., on or about May 22nd of 2023, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of driving while intoxicated, second, while you were operating a motor vehicle in a public place in Jefferson County, Texas. This information further alleges that prior to the commission of this offense on May 2nd of 2019, in cause number M3217883 in the County Court at Law number 3 of Jefferson County, Texas, that you were convicted for the offense relating to operating of a motor vehicle while intoxicated. Mr. Sadler, is that true?
Yes, sir.
Now, to the offense of driving while intoxicated, second, how do you plead? Guilty, not guilty, or no contest?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you are guilty?
Yes, sir.
Mr. Sadler, I also have before me on my tablet a document that is titled Misdemeanor Plea Admonishment. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a signature on, let me see. Yeah, there's a signature above the line that is titled, or next to the line that is titled guilty. Did you place your initials on this document? On page 3 of this same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes.
And on the next document, that's titled trial court certification of defendant's right of appeal.
Yes.
Is this your signature?
Yes.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. You understand the statement?
Yes, sir.
Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
I also have a document on paper that is titled Discovery Certification. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Now, Mr. Sadler, before you signed and initialed all of these documents, did your attorney go over these documents with you?
Yes, sir.
Did you understand everything that your attorney went over?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Sadler, are you a citizen of the United States?
Yes, sir.
State offers States Exhibit 1, Your Honor.
No objection?
No objection. State's exhibit number 1 will be admitted. Ms. Carlton, you've advised and counseled Ms. Sadler. Is there any evidence that she is currently mentally incompetent to stand trial?
No, Your Honor, there's no evidence that he's mentally incompetent to stand trial.
And Mr. Sadler, your attorney, Ms. Carlton, has advised and counseled you. Are you satisfied with her representation?
Yes, sir.
Has she provided full, effective, and competent legal representation?
Yes, sir.
Mr. Sadler, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, we do, Your Honor.
And what is that agreement?
Your Honor, we'd ask the court for 180 days county jail, probated for a period of 15 months of community supervision. The state has
You
agreed
say
to waive
15 months?
15 months, yes, sir.
I had 18 months on the plea form.
Is it 18? It's 18?
Is it 18?
I don't know. You
It
can
was
check.
15.
Somebody,
Yeah, 15.
okay, so who, if somebody wrote 18 on here.
They said it's 18 written on.
It must be my handwriting. My handwriting's pretty bad.
Okay, could you, unlock it? Yeah, just unlock it.
My handwriting's pretty bad.
No.
Those things are not easy to write.
No, that's an 8.
Oh, man.
It's
Your
not a
Honor.
5, that's an 8.
You know, thank you. But y'all got me.
Okay,
Okay.
let me do this here, redo this. Okay,
Thank you, Your Honor.
okay,
All right.
yeah,
Yeah.
okay. This. Could you repeat the offer?
Yes, Your Honor. It'd be 180 days county jail, probated for 15 months of
Okay.
community supervision. And then the state has agreed to waive the fine.
Okay,
And we'd ask the court for repayment of court cost, completion of 40 hours of community service,
okay,
the interlock device requirement, and then the standard terms and conditions for a DWI second. And for the jail time, he is to report on August 29th at or before 6 o'clock.
it was 29. Ah. That's 72 hours. That's. It began in August 29th, 25, before 6 p.m. Gigabyte. Alcohol, what is the other one? It's not assessment, it's the intervention. Let's think of what intervention. Instead, you'd have to check it off, because what we, on the second is the DWI intervention program. You see that box where it says,
Yes, Your Honor.
seven twelve is two, okay. 100, zero, what's the
Do you know
quote?
the number? Is that on there?
300?
The numbers on there.
Okay.
2. Um, 15.
Okay.
You got it, okay.
241857.
Yes, sir. That one's 5 years, so this one's gonna run
This is running concurrent with something?
with the fellow.
Yes, Your Honor.
Oh, okay, so I need to wipe out, okay.
Yeah.
No, determinant. Okay, so that's gonna change that.
Yes, Your Honor. There's a felony that he received probation time. on.
Now, is that gonna, is, okay, it's running concurrent with that?
Yes, Your Honor.
What's the,
Cause number 24DCCR
okay,
1857.
1857. Miss, Redmond, this will be running concurrent with a felony case. And I'm,
24 DCCR 1857?
yeah,
Yes, sir.
okay, okay. Let's see,
Put in the fees, they'll just take care of them.
so that'd be 2, 7, okay.
In your honor,
Seven.
the client is indigent.
Hold on a minute. That, were you appointed?
Yes, your honor.
Okay, hold on a minute. Let's see. Let's see. What's that degree? Let's see. Okay. See. Okay. Mr. Sadler, the state is offering that you serve 180 days in Jefferson County Jail, but this 180 days will be prorated, which means you would not have to serve 180 days in Jefferson County Jail because you'll be on probation for a period of 15 months. During the 15-month probationary period, you will not be required to pay a fine. You're required to pay court costs in the amount of $392. You'll be required to pay a DWI conviction fine fee of $100. You will be required to reimburse Jefferson County Court appointed attorney's fees of $350, and you pay a reimbursement fee of $15. You will not be required to pay the $60 a month probation fee because you're already on probation for felony case. And you will not be required to pay the urinalysis fee of $15 a month because, as I mentioned to you earlier, you're on probation for the felony case.
Right.
Now, your total monthly installments, in this case, that is the total amount that you will be required to pay. Each one is $61 a month. Are you able to pay the $61 a month?
The, on top of the 131, or 130, I'm already paying, probably not, it's none of it, though, I'm very, that's added to it.
Okay. Give me his affidavit.
They're paying 130 a month now.
Okay, okay. Okay. Mr. Sadler, I'm handing your attorney a document that is titled Affidavit of Indigence. Would you please review that document? First page, it has some financial information on it. On the second page, there's a signature above the line that is titled Defendant's Signature. Is that your signature?
Yes, sir.
Now, if going back to that first page that I showed you, is everything on that document still true and correct today? Your finances?
Oh, oh, yes, ma'am. I was looking for- Yes, sir, it is.
Did you add in your college you're having to pay right now?
Oh, no,
Felony?
what happened to that? Probation.
Yeah.
So, that'll be. So,
26.05.
You can tell him.
I think it's 26.
He'll tell you where.
Okay. I'm gonna pay for the probation.
Your Honor, we already put where he's paying for probation on here, because that's new. But would you just add that
No,
under?
okay, I mean, well, I guess at the bottom, let me see the document. Probation fees, yeah, at the bottom where it says probation fees, you can add that
There
in.
it is. We just make it with a bit.
So it's just 100. Actually. And this one is 2.01. Is that it? Yes, it is. Okay. Divided by 14. Okay. May I hit it back?
Yes, Your Honor.
Okay, Mr. Sadler, the court is gonna find that you are indigent. And pursuant to Article 42.15 of the Texas Code of Criminal Procedure. Let's do this here. Now, I'm gonna go back and recite the offer. The state is offering that you serve 180 days in Jefferson County Jail, but you will not be required to serve 180 days in Jefferson County Jail because you'll be on probation for 15 months. During the 15-month probationary period, you will not be required to pay a fine because the fine will be waived. Now, the court cost in this case is $392. That $392 will be converted to 31 hours of community service pursuant to Article 42.15 of the Texas Code of Criminal Procedure. You will be required to pay a DWI conviction fine fee of $100. You will not be required to pay the reimbursement fee of $15 because that will be waived pursuant to Article 102.018 of the Texas Code of Criminal Procedure. The attorney's fees, the $350 will be waived pursuant to Article 26.05 G-11 of the Texas Code of Criminal Procedure. You will not be required to pay a probation fee or your analysis fee in this case because you're paying those fees in the case that's running concurrent with this case. So your total monthly installments, that is a total amount that you will be required to pay in this case is $7 a month. Are you able to pay the $7 a month?
Yes, sir. Thank you very much.
And now you will also be required to perform 40 hours of community service in addition to the 31 that was converted from fine and court costs. So that'll come to a total of 71 hours of community service. That's 31. Oh, make sure I thought I said, hold on a minute, let me do this here. 392,
Yeah. I heard them people with that. It's not.
it's 31, yeah. And let's see. So it's a total of 71 hours of community service that you'll be required to perform. You'll also be required to install an interlock device in any vehicle that you own or operate. You'll be required to attend and complete the DWI intervention class. You have to serve 72 hours in the Jefferson County Jail. That jail time is to begin on August 29, 2025 at or before 6 p.m. You also be required to adhere to the other standard terms and conditions of this probation. And this case will run concurrent with the felony case cause number 24DCCR 1857. Mr. Sadler, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. Sadler, I'll follow the plea bargain agreement that you have entered into with the state. Now, Mr. Sadler, the court coordinator going to take a few more minutes to redo the paperwork.
Okay.
And once she finishes with the paperwork, she's going to call you to come forward. You're going to follow the directions of the bailiff. And once you follow the directions of the bailiff, you're free to go. And you have a
Yes, sir.
blessed day.
Thank you too.
Thank you. All right. Thank you, Ms. Kaufman.
Wanted to see if Mr. Hilton and I could approach him another case.
Another case?
Yes, Your Honor.
Okay.
It is not on the docket today.
Okay. You're gonna have to look that case up. Could you give him?
Your Honor, on the MTRP docket, probation was asking if we could, call, Holt's case.
Okay, we can do that. Yeah, hold on. Let's do this. We're gonna call this here case. This is cause number 24CCCR 1170, case of South City of Texas versus Marcus Holt. Marcus Holt was scheduled to be in court this morning at 9 a.m. At about 9 a.m. Marcus Holt's name was called at the courthouse door by the bailiff. Marcus Holt did not answer. Marcus Holt has not appeared in court since the court has been in session. The time now is 11. It's not 11 yet. It's 10.
Yeah, that looks right.
56 a.m. on today's date of August 20th of 2025. Ms. Bailiff, would you please call the name of Marcus Holt at the courthouse door?
Marcus Holt. Marcus Holt.
Is Marcus Holt?
No response, Your Honor.
Okay, his first name is Marcus. Marcus Holt.
Marcus Holt. Marcus Holt. No response, Your Honor.
Okay. Marcus Holt's name was just called again at the courthouse door. Marcus Holt did not answer. A reasonable time has passed to give Mr. Holt an opportunity to appear in court. It's not appearing in court. State, do you have a motion? That motion will be granted. Marcus Holt bond will be forfeited and a warrant will be issued for his arrest in cause number 24CCCR 1170. Let me do this here. Now.
But we just spoke, and I think we might be able to resolve the cases.
So you just, we need
He's
to
gonna,
cancel
I
the hearing?
believe he's gonna apply for
Pretrial.
pretrial diversion.
So you just need to cancel the hearing? Is that what you was asking for? Now you said set for a hearing?
It was set for a pretrial hearing, yeah.
Pre-trial hearing.
If we can move the hearing back, because I'm going to convey the offer the state just gave me.
Okay.
So we can.
Yeah, we could just do that with the court coordinator. Yeah, they'll reschedule it.
Yeah.
Okay, that's not
Thank
a
you, Your
problem.
Honor.
Okay,
We appreciate it.
Thank
okay,
you,
you're
Judge.
welcome.
Do y'all need anything else from me? Thank you.
That's it.
Thank
You have
you,
a
Your
blessed day.
Thank you.
Your Honor, may I be excused, sir?
Yes, you may be excused.
All right, thank you, sir. Have a nice day.
Okay, thank you.
Let her know if we're getting one. She's out.
Yeah, you said.
I don't know.
Yeah. She will not have.
I may know, I was trying to send it both the judge to see if mine and I'm gonna second send it to you on Saturday. Thank you.
Andrew,
Yes, sir.
I was trying to remove some inadvertently erase the first letter of your name on at the bottom.
I don't. Okay.
I couldn't get that
For whatever-
bottom thing to erase. I don't.
Yeah, I tried that one too.
I never had that problem before. Ty DeMarcus Thompson. Yes, that's what she got DeMarcus from.
Oh.
Mhm.
Thank you.
And you're gonna be in trouble.
Your Honor, and Mr. Thompson is already on probation in another case.
So is that running CC?
It's running.
Yes, Your Honor.
Okay.
$12.72.
Yes.
Okay.
Deferred adjudication.
This is cause number 25 CCCR 0460. Case is styled the state of Texas versus Ty DeMarcus Thompson. Mr. Thompson, is that your full name?
Yes, sir.
Mr. Thompson, would you please raise your right hand? Mr. Thompson, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Thompson, you may put your hand down. How are you doing, Mr. Thompson?
I'm doing good yourself.
I'm doing fine. Thanks for asking. Mr. Thompson, you are represented in your case by your attorney, Attorney James Macon. Attorney Macon, do you waive a record in Mr. Thompson's case?
Yes, Your Honor.
Mr. Thompson, I have before me a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Ty DeMarcus Thompson, on or about November 28th of 2024, while you were in Jefferson County, Texas, operating a motor vehicle in a public place, that you committed the Class A misdemeanor of driving while intoxicated with alcohol concentration level of 0.15 or more. State, are you abandoning the enhancement paragraph?
That's correct, Your Honor.
Mr. Thompson, the state is abandoning the enhancement paragraph. And what that means is, instead of being charged with a Class A misdemeanor DWI, you'll be charged with a Class B misdemeanor DWI, which is a lesser included offense. Mr. Thompson, to the Class B misdemeanor offense of driving while intoxicated with an alcohol the Class B misdemeanor offense of driving while intoxicated while you were operating a motor vehicle in a public place on November 28, 2024, how do you plead? Guilty, not guilty, or no contest?
Guilty.
Guilty. Are you pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you are guilty? Mr. Thompson, I also have before me on my tablet a document that is titled Misdemeanor Plea Admonishment. This document is also labeled as State's Exhibit Number 1. Do you recognize this document? On page 2 of this same document, there are a set of initials. two sets of initials. One set is your initials of your attorney. The other set of initials, TT, are your initials. Did you place your initials on this document?
Yes, sir.
On page 3 of this same document, there's a signature above the line that's titled defendant. Is this your signature?
Yes, sir.
And on the next document that's titled trial court certification of defendant's right of appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
At the top of this document, there are two boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes.
Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes.
I also have a document that is titled Discovery Certification. Do you recognize this document? Is this your signature on the line that's titled Defendant?
Yes, sir.
Now, Mr. Thompson, before you sign and initial all of these documents, did your attorney, Mr. Macon, go over these documents with you?
Yes, sir.
Did you understand everything that your attorney went over?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Jefferson, oh,
Mr. Thompson, are you a citizen of the United States?
Yes, sir.
Jefferson.
Any objections, Mr. Macon?
No,
No objections? State's exhibit number 1 is admitted. Mr. Macon, you've advised and counseled Mr. Thompson. Is there any evidence that he is currently mentally incompetent to stand trial?
no,
And Mr. Thompson, your attorney, Mr. Macon, has advised and counseled you. Are you satisfied with his representation?
yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Macon, Mr. Thompson, I will accept your plea of your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
The agreement in this case is 180 days prorated over 18 months with $1,000 fine, 80 hours community service, the installation and maintainment of an interlock device, and DWI standard conditions of probation. This probation is running concurrent with 24 CCCR 1272.
Okay, let's see. What's the court cost?
$392.
3.
Yes, sir.
what's that?
Okay. Mr. Thompson,
Yes, sir.
the state is offering that you serve 180 days in the Jefferson County Jail, but you will not serve any time in the Jefferson County Jail because you'll be on probation for a period of 18 months. During the 18-month probationary period, you'll be required to pay a fine of $1,000 plus court costs of $392. You will also be required to pay a Jefferson County, you'll be required to pay a DWI conviction fine fee of $100. You'll be required to pay a reimbursement fee of $15. You will not be required to pay probation fee of $60 a month because you'll be paying that in the other case. And you will not be required to pay the urinalysis fee in this case because you will be paying that in the other case that you receive probation on. Now, your total monthly installments, that is the total amount that you will be required to pay each month, is $89 a month.
Yes,
Will you be able to pay the $89 each month?
yes, sir.
You will also be required to perform 80 hours of community service. You'll be required to install an interlock device on any vehicle that you own or operate, attend a completed day-to-day education class, have an alcohol assessment, and adhere to the other standard terms and conditions of this probation. And this case will run concurrent with cause number 24 CCCR 1272. Mr. Thompson, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer is fair and just?
Yes, sir.
Do you accept the state's offer?
Yes.
Mr. Thompson, I'll follow the plea bargain agreement that you have entered into with the state. Now, Mr. Thompson, you're gonna stand at the end of that table, follow the directions of the bailiff. Once you finish following the directions of the bailiff, you'll be free to go, and you have a blessed day.
All right, thank you.
And Mr. Macon, you'll be free to go as well, and you have a blessed day.
Thank you.
Okay. Well, Mr. Thompson. Is he with?
Yeah.
Okay, now, Mr. Thompson, you can come on back up. We just need now, Mr. Thompson, how old are you? How old are you?
25.
25?
Yeah.
And I see here, Mr. Thompson, you didn't come here alone. You have somebody here with you.
Yes,
Who is that?
my father.
Your father? Sir, thanks for coming down here with your son. Okay, now I know Mr. Thompson, by you're 25, and I'll tell people this, I was 25 once too, for 365 days. All right. And, back then, when I was quite young, another thing we had in common, I had hair on my head. Okay. And I have hair on my head now. Been many moons ago.
Yes, sir.
But I know back then, we had people that we really put a lot of stock in. Those people that we called them friends. I know today y'all have people y'all call friends, y'all say that's my BFF. That's my ride or die. That's the person who's gonna be with me through thick and thin, right?
Yes, sir.
But on days like today, when you need a friend, right? Those people that you call your ride or die, we used to call them our ace boom coon. Those people are not here. They had other things to do. But there's somebody that's here with you. And that man did not have nothing else more important in his life today but to be here with you. You know why? Because he loved you. Okay, everybody don't have that. You are blessed to have a father who is standing by you and supporting you. Okay? That's a blessing. And you need to, thank God for that.
Oh, yes, sir.
Okay? Now, I tell people this here, today you might think that you're in a storm, but remember this. When you're walking through a storm, hold your head high. Don't be afraid of the dark. At the end of the storm, there's a golden sky and a sweet silver song of the law. Walk on through the wind, walk on through the rain. Though your dreams be tossed and blown, walk on with hope in your heart, and you'll never walk alone. Everybody's not your friend, everybody's not your partner. But when that man said he got you, he got you. Okay?
Yes, sir.
So sometime today, you need to give that man a big hug and thank him for being the father that he is.
Yes, sir.
Okay? And maybe one day you'll grow up to be a man like him. Okay? All right? So at this time, just continue to, do the things that you're required to do on your probation, and you'll be all right. You could look at this as not as a stumbling block, but as a stepping stone. People use stepping stone to reach higher heights in life. So whatever you want to accomplish in life, you still can accomplish those things. Okay.
Yes, sir.
You can put these things behind you. All right. And just continue to hold on to that man and listen to what he has to say.
Yes, sir.
All right. And you have a blessed day.
Thank you, you too.
And sir, thanks for coming down here with your son.
Thank you, sir.
Okay. All right, thank you. He'll be all right. He'll be all right. Just you doing the right thing. Hey, continue to hold on.
I let him know I ain't turning my back on him, but he did.
Okay, yeah. Okay. Is that it? You have a blessed day, sir.
Thanks again.
Okay. Okay, this is cause number 25 CCCR 0616. Case is style of state of Texas versus Susie Alarcon. Ms. Alarcon is appearing via Zoom. Ms.
Good
Alarcon,
morning. How you doing?
I'm doing
Yeah.
fine. Ms. Alarcon, now you're represented in your case by your attorney, James Paget. Attorney Paget has not made an appearance in court this morning. We did make an attempt to contact his office. Is that correct? And we have not received a response. So therefore, Ms. Alarcon, he may be in another court handling another matter. And so your case is going to be reset. Stay in contact with your attorney and your bondsman. Thanks for being patient with us. And you have a blessed day. You're free to go.
Okay, thank you, sir.
Thank you.